This is Duke University.
Good afternoon. My name is Neil Siegel, and on behalf of the program in public law here at Duke Law School, I am very pleased to introduce today's panel discussion on McDonald against City of Chicago, one of the most important high-profile decisions of the Supreme Court of the United States during the October 2009 term. Our story begins in 1791, when the Second Amendment was added to the Constitution. It provides that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Fast forwarding a few years in the interest of time, in 2008, for the first time in American history, the Supreme Court held that the Second Amendment protects an individual right to possess a firearm, including a handgun in the home for purposes of self-defense. Because D.C. was involved in D.C. against Heller is a federal enclave, the court did not have occasion in Heller to decide whether or not the Second Amendment right articulated in that case also binds state and local government. In the language of constitutional law, the question that had not yet been decided is whether or not the Heller right is incorporated into Section 1 of the 14th Amendment. In the McDonald case, the court, again fracturing 5-4 in the apparently ideological way that it did in Heller, held that in fact the Second Amendment right articulated in Heller is fundamental, it is deeply rooted in the nation's history and tradition, and therefore is incorporated into Section 1 of the 14th Amendment. The dissenters rejected not just the court's conclusion that the right is fundamental, but also rejected the court's methodology, and specifically its near exclusive focus on history and tradition. For the dissenters, history offered guidance, but that the court and the country need not be beholden to it, because, of course, some of the country's history and traditions involves quite pernicious traditions that subsequent generations in case law has rejected. And so a real debate about both the outcome as well as the methodology of interpretation. I've invited today's panelists to reflect on the McDonald decision, the soundness of the reasoning, the result, the implications going forward. And we have with us the Supreme Court litigator who argued D.C. against Heller for the District of Columbia, Duke's own Walter Dellinger, who also also directs the appellate practice group at O'Melveny and Myers in Washington, D.C. And joining him as well is Joseph Blocher, who not only teaches constitutional law here at Duke, and not only writes about the Second Amendment among other subjects, but also assisted Walter in litigating Heller before the Supreme Court. And joining them is our colleague Tom Metzloff, who directs the Voices of American Law project, which interviews the litigants, the experts, the judges in constitutional cases implicating key constitutional values like Heller, and then creates detailed documentaries that are used in educational settings, including law schools. Tom is currently working on a video on the Heller decision and has been interviewing, among others, Walter Dellinger.
Still need to interview Walter.
Okay.
My last.
Well, this was merely informational. This was not intended to put pressure Walter into an interview. Okay, we're going to begin now with Professor Blocher, and he'll speak for roughly 10 minutes, and then we'll turn to Professor Metzloff, and then finally Walter Dellinger will share with us his reflections on the case.
Sure. So as Professor Siegel's intro indicated, there is a lot that one could talk about with regard to McDonald. But I have to say, in choosing one thing, I was particularly inspired by the poster for this event, which you guys may have seen outside, the full-size one, has this giant handgun on it, like a 2-foot handgun with a barrel like the size of your arm that shoots like cell phone-sized bullets. And I was looking at it and I was thinking, man, like, after McDonald, can North Carolina regulate that? Because if that were to fall into the wrong giant hands, we would all be in danger. And so I thought maybe I would focus especially on the implications of McDonald and inevitably of Heller going forward, sort of the implications for the constitutionality of gun control. And so the first place to start, I guess, is, well, what's not okay, right? What is unconstitutional? And we know from Heller and McDonald that it is not okay for the federal government or for a state or a locality now to ban handguns, the possession of handguns in the home for the purposes of self-defense. But that doesn't get us very far because it turns out there's not a whole lot of laws that do that. Right? There's maybe a half a dozen that I've been able to find, cities and no states that do it. So what does that tell us really? right? Both Heller and McDonald explicitly don't create a standard of review for governing Second Amendment claims, right? None of the strict scrutiny, rational basis kind of stuff, which you guys have probably seen in con law, right? So we're not left with that kind of guidance. And we know from Heller that we're not allowed to balance the interests of the individual against the interests of the government, right? Heller says you can't do that, right? So what can you do, right? What's okay? And McDonald doesn't tell us anything about this, but it does point us to Heller, which does say a few things. So Heller tells us that it is okay, for example, to ban felons from possessing guns. It says it's okay to ban the mentally ill from possessing guns. It says it's okay to ban dangerous and unusual weapons. And it says it's okay to ban weapons in sensitive places like government buildings, right? So we have these sort of 4 data points that are okay, and we have this one that's not, right? But we don't have a test that tells us why these are okay and this one's not, right? And so going forward, how are we supposed to make anything out of this? Now one thing we could do, if we're going to be sort of clever constitutional mathematicians here, right, is try to derive the equation, right, that connects these dots, right? Like, what is it that these have in common, right, that makes this okay? Because if you can figure that out, maybe you know what your test is, your standard of review. But, and I'd be happy to hear if anybody can do this, because I'm stymied. I can't figure out any possible rule that makes these 4 things okay and this one not okay, right? So one option might be to say, well, the amendment is about self-defense, right? So things that burden the common law right to self-defense are unconstitutional, right? That would explain the handgun thing. But it wouldn't explain felons and the mentally ill, right? Because they have a common law right to self-defense, right? You couldn't carve them out. They can defend themselves under the common law. So can children, right? So can illegal aliens. So can drug users, all of whom don't have, unlimited rights to bear arms, right? So that line doesn't work, right? So maybe instead it's about tyranny, right? That the whole point of the amendment is to allow us all to have guns so that if the government starts overreaching, we can rise up, right, and deter it or fight it off or whatever, right? And federal government under Heller, state government under McDonald, right? But if that's true, then it doesn't make a lot of sense why you would exclude dangerous and unusual weapons, right? And it doesn't make a lot of sense why you would exclude sensitive places like government buildings. Because, after all, if you wanted to deter a tyrannical federal government and fight it off, what would you do? You would grab your flamethrower, right, and go down to town hall, right, or to the Supreme Court, right, and let them have it. So after McDonald and Heller, even putting them together, I think we not only don't know what's okay, but we don't even have a way to think about what's okay, right? There's no test. So going forward, this makes it hard to talk about what the implications are going forward, but what's going to happen, right? I have a few thoughts on what's going to be challenged, what kinds of laws are going to be challenged, and maybe how the courts are going to go about resolving it. So one area that I think is going to be really interesting being challenged going forward is what are called safe storage requirements. Right? So this was also at issue in Heller. Right? D.C. had a regulation that required you to keep your gun locked or disassembled when you're not using it. Right? And that got struck down for kind of a weird reason. It doesn't necessarily mean it's always going to be unconstitutional, but it definitely does burden one's right to self-defense. Right? If you have to unlock your gun, right, it might take you 3 seconds, 5 seconds, a minute, whatever. We did this exercise with Walter when we were arguing the case, and he did it in 3 seconds, right? But not everybody maybe is as quick with a lock, right? And somebody's in your house, how can you possibly wait, right? On the other hand, that's the whole point of a lock, right? It's to prevent kids, for example, from getting into guns and accidentally shooting themselves or each other, right? So there's big interest on both sides of that. And honestly, I'm not sure whether courts are going to find them constitutional or not. So the second question is, well, what question are they going to ask, right? If you're a judge and you get that case in front of you, where do you start, right? It's not felons, it's not the mentally ill, it's not a dangerous, unusual weapon, it's not government building, and it's not a handgun ban, right? So how do you even start to evaluate it, right? And the court said no balancing, right? How are we going to develop a test? And I'm not sure how that's going to shake out. I don't think the Supreme Court is going to take another Second Amendment case to articulate a standard anytime soon, but could be wrong. I think there's one intriguing possibility, which I just want to flag, which is that the federal courts could do worse, I think, than to look to the state courts for guidance on this question. And this is something which you don't get a lot of state constitutional law in law school here, but it's a fascinating thing and really important, and in this area particularly, because it turns out that the states are way ahead of the federal government and the federal courts in recognizing this individual right to bear arms, right? So we didn't have that under the federal Constitution until 2008 in Heller. But the states, all of them, have that right under their state constitutions, right? So 48 at least, or 49 do. So we could just look and say, well, what do they do, right? What's their test? What tests do they apply? And it turns out, conveniently, that they all do the same thing, right? They all use the same test, right? At least last time I checked, there were 44 state courts that had looked at this, and they all arrived at the same conclusion, which is that the proper standard of review is reasonableness, right? It's not strict scrutiny, not rational basis. It's kind of in between. It's a little bit like intermediate scrutiny, maybe. Basically says a piece of gun control legislation is constitutional so long as it's reasonable, right? Some laws get struck down, a lot of them get upheld, but if we're going to be sort of, looking for guidance, and the Supreme Court hasn't given any, I think you could do worse than taking that test. And I should say, just to bring this back to the McDonald, right, because that is why we're here, I guess, it fits well, I think, with the sort of jurisprudential approach in McDonald, right? So as you remember, in McDonald, the court incorporates the Second Amendment because it finds this right to bear arms is, rooted in our traditions. It's fundamental, right? It's part of our constitutional culture, right? And it does that, in part, by looking at the states and what the states do, right? And if you're going to look at what the states do and use that as the basis for incorporating the right against them, well, you got to look at what they actually do, which is protect the reasonable right to bear arms, and not the right to bear arms, independent of any possible state regulation. So I think it fits pretty well with the approach the court took there, right? So that's my sort of normative argument there. And just to bring it full circle, I would say I think that it would be reasonable for North Carolina to regulate that giant gun on the poster, or at least I hope so.
I don't know which mic I'm supposed to be using. Are any of these working? Oh, that one's working.
Okay.
It's interesting, the idea of a flamethrower to the Supreme Court, the Second Amendment weapon of choice that I would suggest would be a paper shredder. I was going to ask how many of you have read the McDonald decision, and I'm confident that the answer is nobody in its entirety. It is long, and this provides a term with the bookend case. The first major case of the year, the first one argued, was Citizens United, coming in at about 200 pages, and this one a little bit longer. And so there is this sort of sense of, what is really going on with the court that these have become the sort of norm in terms of the decisions, because I was teaching a high school course for the Duke TIP program this summer, and these folks were helping me out a little bit. And you start with affirmative action, you read Brown versus Board of Education. You don't have to edit that. You can just give it to high school students. It's 6 pages long. Unanimous decision, completely changing the entire structure of American culture in 6 pages. And here we have a decision that requires, you have to set aside a day to read and reflect on it. And the answer in some respects is why? What is going on? Now, part of it is this, and I really almost want to do a study on this to see if this is gone through. I've gone back to the term that I clerked back a million years ago, looked at the decisions that I worked on for Justice White, and we never spent a lot of time, maybe a footnote, responding to something in the dissent. And I remember Justice White saying, no, just say what we're going to say. People can read both and make up their own minds and agree with it. We now have chapters in these opinions where the justices you say, well, now let me deal with the arguments in the dissent. And here we have separate opinions on that. Justice Stevens, his last opinion that he wrote, this was the final case of came out on the final day of the term, has a very lengthy concurring opinion. And Justice Scalia felt compelled to write a very lengthy, Stevens was dissenting, but Scalia concurring, basically saying, let me just talk about why Justice Stevens is really wrong. And going on for page after page. At the end of the day, why? Why are they doing that? Now, the other reason we might need a paper shredder is this is kind of the fun, typical dysfunctional Supreme Court. We have yet another very interesting take by Justice Thomas, and yet now another line of cases that he wants to overrule. I keep teasing Neil that we need to create this list, that it'd be about 100 cases where he has said, while I have to decide this case, I really think we should overrule the following 72 cases here, and he's got that again. Now, and this is one where I think the con law professors, and maybe Neil and Joseph and Walter can speak to that. There's something to it. I saw our old friend Bill Van Alstyne this summer, and he was really intrigued with Thomas's effort to go back to the slaughterhouse cases, to go back to sort of the history of incorporation and say, it's been kind of weird how we've gotten where we are. Why are we incorporating things through the due process clause of the 14th Amendment rather than through privileges and immunities? And his exposition is very interesting, and it's very long, And it's very historical, and there's some very interesting stuff in it, but it is completely different than anybody else is approaching the problem. Now, if I were to have asked first-year law students, and maybe that's not the right group to judge, all right, we've studied Heller. You can agree with it or disagree with it, and I think there's many people on this panel who will disagree and would prefer to have the dissent had won for many reasons. That's a different discussion. But once you're done with Heller, the question is, all right, are we going to incorporate it? It is the Second Amendment. The whole point of the incorporation doctrine since the New Deal has been basically that we have incorporated, those sort of core values that are expressed in the Bill of Rights. We've incorporated wholesale even things like Mapp versus Ohio, the exclusionary rule, jot for jot. Justice Brennan speaking very eloquently about the necessity for incorporation completely of key rights. I mean, there's only a very few number of sort of core Bill of Rights values that we haven't incorporated. One is the Seventh Amendment with civil jury trials, my area of civil procedure, and it doesn't make any difference because every state has almost an identical jury trial right. So there's been no significant disagreement. So if I were to ask a first-year law student, all right, so what's going to happen if you're honest as a justice and accept Heller and stare decisis and all that good stuff that we talk about but nobody really seems to believe on this court anymore? This should have been easy. This should have been a 10-page decision with a 2 or 3 page dissent, and instead it's all over the map. And so I looked and I read Justice Alito's majority opinion, and I think it's very straightforward. He said, if you look at the history of the incorporation, this is how we do it. And since then, and you take the good with the bad. And so, while maybe the conservative justices would have preferred not to incorporate some of the more liberal values that have been done, okay, we've done it. We're not going back. And so I look more to Justice Breyer's dissent to say, why didn't you agree with this? Because this, the real battle is coming up. It is. What is the standard for these tests coming up? And we learn nothing from the majority on what that's going to be. They don't engage it at all. And so, when I read Justice Breyer's dissenting opinion, he starts by saying, I really didn't like the result in Heller. His first quote is from an amicus brief filed by a group of historians of English history from both the United States and England, who conclude that the Supreme Court got the history really wrong. Now, it's a nice point. If you're going to be Justice Scalia and all that matters is history, and somebody says your history's bad, I suppose that counts for something. And he sort of says the history of the Second Amendment, the history of the right to bear arms in England was not the people defending themselves in their house. It was to make sure that the Parliament always had the opportunity to call up the people to defend themselves against a king that had usurped authority and power. And he has this stunning statement for a judicial opinion. There's some historians on the other side, but it's 8-1 in favor of this view of history. And so if we were taking a poll, and maybe we should be. So basically he says, it's only 2 years old, let's overrule Heller. Okay, maybe so. I didn't think there was any chance of shaking any of the 5 votes on that point. Maybe that's for the future, that we're sort of putting down a marker that if and when the politics changes and the justice compositions changes, Heller is not on secure footing. That's fine. But then you go beyond that. I find the dissent pretty unpersuasive. They say this is not fundamental. They try to get back to the due process clause being about sort of judiciary and those things, but that train left the station a long time ago in the incorporation doctrine. And it doesn't make sense, and it didn't make sense in the 1930s, 40s, 50s, and 60s. At the end of the day, this in Heller is a fundamental right, and it includes the fundamental right to protect yourself in your home with a handgun. That could be, again, that's wrong. That's because Heller's wrong. I thought the incorporation, this case should have been a lot easier, I think, than it was.
Thank you very much. Walter.
Well, let me begin by saying what I think is serious and thoughtful about the constitutional claim that restrictions on gun use, ownership, or deployment violate constitutional principles. And that is to begin just briefly where Justice Stevens begins in his McDonald dissent, in which he says, this is a substantive due process case. And he goes on to take quite seriously, and I think rightly so, the claim that there is a very substantial liberty interest that ought to be judicially recognized that would protect some use of guns from certain kinds of regulation. I think in particular one strand is that there is, in my view, a very serious case that there is a constitutional right to self-defense. That is, the government cannot arbitrarily restrict one's right to defend oneself without showing a very compelling reason for doing so if there's a serious incursion on the right of self-defense. The reason I think we have not had litigation around the right of self-defense is that 50 states recognize in fairly strong fashion in their criminal law that there is a right of self-defense, so that it's so well entwined in our political culture that it hasn't been challenged. I also think that Justice Stevens is correct in recognizing that there's a very strong claim of a right to the possession of a gun within the home. That is, if the particular issue buried within McDonald is whether there is a right to possess a handgun in the home. And there, too, I think there's a very substantial case as an individual liberty right that particularly in the home where Stanley against Georgia protects the personal use of what would otherwise be bannable, obscene materials as long as it's in the home, there is a lot of protection around that. Justice Stevens thinks the case is not quite made out as a substantive due process case about a right to have guns in the home unless you could show a particular gun, a handgun, that, for example, you were an elderly person who could not make effective use of a long gun, which is permitted. So on balance, he thinks the case is not made out, but it's a very substantial case. That there is a tradition of liberty that includes the use of guns for self-protection, especially in the home. Now, the problem that poses for the Heller and McDonald majority is that at least four of them fairly thoroughly repudiate the notion that the court should be articulating what are substantive due process values. These are those who argue that Roe versus Wade should be overruled. Some may even doubt Griswold against Connecticut and other cases. So that is the problem for these justices. The justices who actually believe that courts can articulate certain kinds of liberty values as protection against majoritarian impulses are not particularly swayed by the argument that gun rights fit within that. And the justices who are more sympathetic to the claims of gun rights repudiate the jurisprudence. So that takes us then back to what would be the easy case of saying, well, Heller has already decided that there's a Second Amendment, there's incorporation. So let me address that for a moment. There are two ways to argue that incorporation is not the answer in this case. One is to say that, look, there really is no such thing as incorporation in the sense that the majority is assuming to be the case. And secondly, that even if there is that kind of incorporation, the Second Amendment, because of its very nature, wouldn't qualify. Let me start with the first. I think there is something of a myth of incorporation, at least a half a myth. The Supreme Court addressed the question in the 1940s in Adamson against California of whether the 14th Amendment, Section 1 of the 14th Amendment, as Justice Hugo Black saw it, the due process and the privileged immunities clauses taken together, whether the meaning of that clause, those new restrictions placed on the states by the federal government, whether the meaning of those was to be gained by looking at the first 8 amendments to the Constitution and assuming that Section 1 of the 14th Amendment incorporated those rights and made them applicable against the states. The Supreme Court rejected the idea that the framers of the 14th Amendment intended to incorporate the first 8 amendments and apply them to the states, and it has never revisited that. Now, in 1925, the Supreme Court did something that is almost universally flatly mischaracterized. It is said that in 1925 in Gitlow against New York, the Supreme Court incorporated the First Amendment and made it applicable against the states. It did no such thing. It looked at and defined the Liberty Clause of the 14th Amendment, and it said that the freedom of speech, that's small f, small o, small f, the freedom of speech is part of the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. It said nothing about incorporation. The relevance of the First Amendment is that when you're arguing that a certain right is fundamental, the fact that the very first Congress proposed amendments to limit the national government is a strong datum that that's a part of our tradition. But that's all it is, and I think that the notion that if you look at all of the earlier cases, Stromberg against California as well as Gitlow against New York, all of these cases look at the Liberty Clause of the 14th Amendment. They're substantive due process cases. It's a fundamental part of the liberty. So that you can't, there's never in that sense been any suggestion that the framers of the 14th Amendment intended to incorporate the First Amendment. But looking at the liberty that is protected by the 14th Amendment, that it is part of those fundamental liberty values. Now, in the mushy years of the Warren Court, when they were not, I think, writing very articulate opinions in cases like Duncan against California, one of the things they did do is when they were defining the procedural protections, like right to trial by jury, instead of starting from scratch and deciding what the protection should be against the states under the 14th Amendment, they looked to what they had also done under the Bill of Rights as it limits the federal government. That's a natural place to look, but that's not really incorporation as such. It is just a reference over to procedural rights and to what is the 14th Amendment. So I think the better view has always been that of John Marshall Harlan and Lewis Powell, who have always had it clearly in mind that the 14th Amendment stands on its own bottom and protects the Liberty Clause. So in that sense, I think you don't look to incorporation. Now, if you do look to incorporation, you're looking to the right, the underlying right. And it seems to me that there is not a very strong case to be made other than the basic substantive due process case, that anything in the Second Amendment would lead you to believe that this is a right that should be applicable against the states. There were many themes to the Second Amendment, but I think Heller was just flatly wrong in assuming that the Second Amendment was about the individual use of arms to resist tyranny or for self-defense or for hunting. Those all were valued by the founding generation, but were not part of the Second Amendment discourse. Now, Tom raised a very interesting question. Here's the issue, Tom. Assuming that you're bound by Heller, by the result, are you bound by an intermediate premise of a case if you believe the intermediate premise is wrong? So that Heller, it seemed to me and to Joseph when we worked on this, I believe it creates an individual right such as, but that right was about the federal government not interfering with the state's ability to create its own freestanding militia, and an individual's right to that use of weapons that would facilitate participation in the militia. That might mean an individual right against certain kinds of federal gun regulation that would impair the capacity of the citizenry to participate in militias. It might well do that. But to look at the history, it comes over to me, I thought with such clarity, Joseph, and I know you did too, that the historians we dealt with, when the new Constitution was proposed for ratification in 1787, it was shocking. Drafted in secret in Philadelphia in the summer of 1787, beginning May 25th, and proceeding in secrecy throughout the months of the summer until it was revealed on September 17th and submitted to the states for ratification by or rejection by popularly elected conventions in each state. It was an astounding document. The convention had been called to propose revisions to the existing confederacy of independent and sovereign states, and instead it created a new national government, continental in scope, with the power to legislate directly upon individuals. And one of the shocking parts of it was that it created the capacity for a national standing army to be appropriated every 2 years, but Congress could create an army and a navy. Heretofore, you had relied upon each state to supply its own regiments and to control them. They fought the Revolutionary War as allies, not as a union. They didn't even have uniforms. So it's shocking that the national government could create a military, but that's half the shock. The rest of it comes in a provision about the state militias. And it says that Congress shall have the power to arm the state militias, to provide for the arming of the state militias, and to determine the protocol by which they shall be trained. The power to arm the state militias is the power to disarm them. The difference between a state militia and a standing army was very dramatic, because the state militia were individuals who put down their implements and their tools, took up their musket, and returned to the citizenry when the threat was over, rather than a professional standing army, which was seen as a threat to liberty. But a militia could never be a threat to liberty because it was made up of the people themselves. So if Congress could control the state militias and create a standing army, this was the greatest threat to the states. And there was an insistence on an amendment that would give power over the state militias back to the states. Madison's compromise draft says a well-regulated militia being essential to a free state, the right to keep and bear arms shall not be infringed, shall not be infringed. And, you know, I think deliberately ambiguous on Madison's part. He didn't want to cede full control back to the state militias. He thought democracy run rampant in the state legislatures was part of the problem, to which the Constitutional Convention was called to articulate a response. So that was the background. There were Blackstonian talks about individual rights to have guns as one of Blackstone's liberty. But as we said, I don't know why Breyer thought he had to bring it up in McDonald. We said in Heller, in the briefing, that Blackstone said subject to regulation by law, meaning that Parliament had the right to protect the use of weapons. The king could not prevent Parliament from having an armed citizenry for self-defense about the king. So if you look at the Blackstonian right, it was quite a hedged right. So there's not a great tradition out there. And therefore, I think when you're asking, when you apply the establishment, when you apply the issue of incorporation, the way it should be applied, you look to an amendment for guidance, like the Second Amendment or the First Amendment. And you look at the kind of right that was created and see that as part of our tradition. Now, the court's holding invalidated restrictions by the national government on handguns. But there's a good case to be made that that was all about protecting the right of the states to be free of federal interference with the regulation of guns. It seemed to be quite consistent with the right created by the Second Amendment, that states could decide that certain kinds of weapons should all be kept in a central repository for access in times of crisis. That states were given authority over the regulation of guns. It was taken away from the national government. So in that sense, it turns the Second Amendment literally upside down to let 5 federal judges of the national government tell 50 state governments what to do about gun regulation, when the Second Amendment was designed to protect the states in their autonomy over the use of guns and the supplying of their militias, and maybe having even an individual right against the national government if it was going to interfere with one's ability to participate in a militia. Which brings me back to just two final quick points. One is that there are many ways to define activism, but reaching out unnecessarily to decide an issue before it's time is one of those ways. And I suppose the one thing that I have the hardest time letting go of is my concern over the court's failure to address the fact that this was the District of Columbia. This was regulation adopted by the D.C. City Council on authority of the Congress having delegated that authority to the D.C. City Council, a regulation within the 10 square mile area set aside as a federal enclave. And of course, it's the case that citizens, residents of the district have the same Second Amendment rights as anybody else. But the question is, what right does anybody have to possess weapons or display weapons or whatever within this 10 square mile area that was created by the Constitution as the seat of the federal government? The one thing of which I am mortally, absolutely mortally certain is that if you ask any of the framers about this question, remembering that the District of Columbia clause of the Constitution says an area not to exceed 10 miles square to be the seat of the national government. It could have been 10 blocks square. In fact, I think a real mistake was the first Congress making it 10 square miles. It made it too much like a city rather than more like the Federal Triangle. But the framers had no way of knowing how large within the maximum of 10 square miles the enclave would be. If you ask Congress whether the Second Amendment, adopted when states protested national interference with their ability to have a militia, whether it would constrain Congress's right to regulate weapons within the 10 square mile security area created for the national government, I think they would have thought you were nuts. That of course Congress has plenary authority, just as it does over Fort Bragg, over that 10 square mile area to regulate guns. But nobody wanted to focus on the fact that this was not national legislation trying to regulate what people do in Wyoming or Oregon or Utah as well as Chicago and Washington. It was regulation by Congress's delegee of the security area within the 10 square mile. Nobody wanted to do it because this case had been served up as the great Second Amendment case. So nobody wanted to pay any attention to the fact that it wasn't, that it was a local ordinance adopted in the area over which Congress has plenary national security authority. And that kind of, and nobody on the court showed any interest. And I can understand why. When I was preparing the case on a Sunday afternoon for Tuesday morning, I turned on the television in my office to get the sports scores of the afternoon, and the local news came on.
Carolina lost.
That's an easy prediction these days. There were lines of people outside the Supreme Court with sleeping bags a day and a half before the argument. I cut off the TV and went back to preparing. But I think the court thought it was set up for a grand issue and they wanted to do it. And my final point will be this about, I think it's once again, I think somewhat sobering to see how at best this would be an ambiguity about the Second Amendment, at best. And if that's the case, why not take 137 years of settled history? Why not defer, if it's that uncertain and ambiguous, why not defer to what different states and localities have done? What struck me about the certitude of more of the Heller opinion than of McDonald was this. When John Roberts was at his confirmation hearing, there was a big debate. Neil, you'll remember this, you may have participated in it, I believe, in whether John Roberts was going to be a minimalist who would show strong respect for precedent in spite of his own politically conservative views, or whether he would be a more maximal, activist judge. And I was somewhat uncertain about where I what I thought was likely to be the case. Until he said in his testimony that in his view, the job of a justice was to be like an umpire and just call balls and strikes. And when he said that, I thought, oh my God, he's going to be an activist. Now, that sounds counterintuitive to you. But the reason is that if you say to others or even to yourself that your job is, all you're doing is calling balls and strikes, you feel very comfortable in setting aside what Congress has done with campaign finance regulation. You feel very comfortable in setting aside what lots of cities have done about the possession of easily hidden guns, et cetera. You feel very confident of that. It's the justices who more candidly acknowledge the existence of choice and judgment, like Lewis Powell and John Marshall Harlan. Those justices who say the job involves the exercise of judgment, they're the ones who are more often restrained in imposing and substituting their own views for those of the democratically elected branches of government.
Thank you very much. Those are some, from each of you, very illuminating observations, both on this decision as well as on constitutional law more generally. We have some time. I want to offer a few thoughts in response to what's been said and give you folks an opportunity to respond if you like, or we can open it up to questions as well. I'm just going to call you Joseph. I never know at these events how to refer to my colleagues. You can call him Professor Blocher. Right? It's
Dr. Blocher to you, Neil.
Right, Dr. Counselor Blocher, Esquire. The important thing is that both of these two are Carolina fans, and I didn't know that. I just had to infer the circumstances under which Walter would email me, and it always was when Duke lost and Carolina won. And then over time, that's when he wanted to talk about basketball, and I realized what was going on.
So you all haven't been in touch a lot lately.
Nah, exactly. It's good to see you after a long time. So Joseph asked the question of what kind of Second Amendment is the Second Amendment that the Heller and McDonald court has articulated, and how do you connect all the data points, right? Try this on for size, right? Without defending it normatively, does it account for all the data points, right? It's clearly it's not an anti-tyranny Second Amendment, a small R Republican Second Amendment, right? That goes out after the militia violence of the 1990s, which the court is going to distance itself from, and is going to reject that. And it's not a simple self-defense amendment, but what about a law and order Second Amendment? Right? This is the right of responsible and law-abiding citizens to defend themselves and their loved ones from criminals, at least in the home. I think that goes pretty far. You don't need dangerous and unusual weapons to protect yourselves from criminals. You're not going to be attacking the government. You don't need access to sensitive places. If you're a felon, you're not law-abiding. If you're mentally ill, you may not be responsible in the relevant sense. Right? It's a sort of product of the Nixon years and beyond, right? That this is about law-abiding citizens protecting themselves from criminals, and then the question is, what does that have to do with the actual Second Amendment? I think Tom raises some important questions that I think many of a more conservative jurisprudential disposition have asked people of a generally liberal disposition, which is, why is turnabout not fair play here? It's you liberals who created incorporation. It's you liberals who for decades applied all these rights to state and local governments, right? Why don't you just agree here that if Heller is right, you may not like Heller, and Walter has just told you how wrong he thinks Heller is, right? Why not just say the incorporation question is easy? And I would say two things in response to that. One is, it seems to me both sides have some explaining to do, right? Because the Alito opinion so focuses on history and tradition, right, to accept incorporation, to incorporate this right, but does it in a way that declines to endorse the rights to abortion, right, to rights to sexual privacy that are protected, right, in the Lawrence decision. If you take what the majority is saying seriously, you also have cases like Loving versus Virginia, right, which say that racial intermarriage is part of the fundamental right protected, and that's a problem for the court. So I think both sides have explaining to do. Why are you so enthusiastic about applying a jurisprudence that in fact is substantive due process that you so routinely reject as Justice Scalia says licensing judicial whimsy. I also think it's fair to say, is it really true that total incorporation has been what the court has done? And I think Walter has said this. In fact, it has been selective incorporation. There are some important rights that have not been incorporated, right? In a state criminal prosecution, you don't have a right to indictment by a grand jury, right? For example. So maybe there is something about the individual right protected in Heller that deserves specific inspection. It's not just wholesale, you incorporate everything if you incorporated rights from the past. Walter, you've said you've said a lot. I want to underscore what you've done implicitly, which is draw attention away from the Breyer dissent, which Tom focused on, to the Stevens dissent. I think this is one of the most important opinions Stevens has ever written. It's a rare instance of a judge in his official capacity trying to come to terms with the fact of judgment and judicial discretion from the internal perspective of the faithful practitioner of the law. Judges usually just say stuff like, I'm calling balls and strikes. I'm just applying the law. I'm not making the law. It's for the law professors and the political scientists, right? And the politicians sometimes to say, give me a break. Of course you're making law. Here is a judge saying, yes, we have to exercise judgment. We have to exercise discretion. How do we deal with this? It's important to allow it for certain reasons, but we also have to limit it, right? And this sets Justice Scalia off, saying you're just licensing whimsy. This is lawlessness. And yet, Scalia's opinion seems suffused with prudential concerns of their own. They're not as explicit, just like the Heller majority has prudential concerns. Those data points Joseph listed are, I call it the list of don't worries, right? Don't worries, we're not going to do something crazy, America, right? The NRA is not going to win every time. Certain things are out of bounds. Why? We'll tell you later. We'll do the historical analysis later, but don't worry. So it seems like there's a lot of prudential concerns all around. Walter, when you say it's just so clear to you, when Justice Scalia was here not long ago, it was so clear to him. He took me aside and he said, I can't understand why they chose to take me on my own territory, on my own grounds, on originalist grounds. The history is so clear, I am so right. So what do you do when both sides think the history is so clearly right? Right? What does this say about originalism as an answer to the problem of judicial discretion, as an answer to the problem of exercising the human faculty of judgment? And the last thing I'll say is, Walter, is there something of a tension between where you began and where you ended? Right? So even if you're right about the Second Amendment, if you think there's something about liberty standing on its own bottom that to some extent protects an individual right to possess some sort of firearm for purposes of self-defense, right, then maybe the Second Amendment is not the place to go in Heller. Maybe it's the Fifth Amendment, and maybe it's the liberty of the due process clause.
Absolutely. I totally agree with that. I thought there was, and I said to Bob Levy and others at Cato that who were sort of sponsoring this litigation, I said, you know, there is a very credible claim to be made about a handgun ban particularly if you would restrict it to a handgun ban of possession of handguns in the home under the Fifth Amendment, under the Liberty Clause of the Fifth Amendment. Absolutely, I do think that's, and I agree with Stevens. I may be more inclined to think that you could make out a case for a libertarian right under the Fifth Amendment. You would be invoking the Fifth Amendment in the District of Columbia, or the Fifth Amendment against national legislation, and the 14th Amendment against the states. Right. But that's not a route that there were votes for on this court. Right. But that to me was legitimate. One other thing about incorporation, the issue arose about the Establishment Clause, which is similar to the Second Amendment in that there's a credible argument in each case that the amendment was designed to protect state authority. Indeed, some have said that the Establishment Clause was intended to prevent Congress from interfering with state establishments of religion. So that if Virginia wanted to recognize the Anglican Church as the official church of Virginia, the First Amendment prohibited Congress with making any law with respect to the establishment of religion. I think there's a lot to that. And I would be very, very dubious about any argument that the Establishment Clause is, quote, incorporated by the 14th Amendment and made applicable to the states. Now, I think that doesn't change the result in any of the court's cases, because I think there's a strong liberty argument, not, that you can raise your children and your family in our constitutional tradition, in a culture where the government doesn't tell you what is the official religion, the state government cannot tell you that the Baptist religion is the official religion or tell your children it's the official religion, and that you reach that under the 14th Amendment, even though it's not, quote, incorporating the Establishment Clause. So I have basically the same view on the Second Amendment and the Establishment Clause, that both of them were particularly directed to the problem of having the national government with authority to regulate firearms or regulate the establishment of religion, and makes each of them particularly ill-suited to any notion of incorporation. That doesn't trouble me, because in each case, I think you look at the issue directly under the liberty clauses of the Fifth and 14th Amendments.
Right, so this is a view of the Establishment Clause as a federalism provision. That's Justice Thomas's.
Like the Second Amendment.
That's
right.
Justice Thomas's view, and Justice Stevens sees the Second Amendment as a federalism provision. Right.
I think they're both right.
All right, and each one thinks the other is wrong about the other amendment.
Neil, I just wanted to agree with you about, kind of what is the vision of what this right's going to be. One of the frustrating things for me, because I am interested in sort of the documentary side of this, and there's not a lot of potential here, there's very little narrative in this case, but to the extent there is one, the majority tells the story of Chicago putting in a handgun ban and point out, I think totally gratuitously to the result, that it hasn't worked and that the murder rate is higher in Chicago than it was before. The dissent, Breyer tells the story about the other city, Oak, what's the name of the other town that had the ban?
Oak Park. Or
Yeah,
Oak Park.
Oak Grove,
Oak Grove,
Right.
part of a suburb of Chicago, which put in its ban after a local lawyer was killed by a client who brought a gun into the courtroom, and how the people then had a referendum and vote, and it's a safer community. So they're telling very different stories. One of the plaintiffs from Chicago is someone who is very activist in terms of neighborhood protection, and has been threatened by drug dealers and the like. So he is the poster child for your vision of what this is, and I think that's exactly what it is. It's the good citizen who is out there protecting the community, and they'll articulate that later. So I think that's exactly right, and I think we're going to learn more about the narratives as these cases now go forward. They're tough questions. I mean, Breyer scores a lot of points when he says, when we get to these tests, is the empirical evidence going to matter at all? How are you going to know if a handgun ban went in, if the murder rate is up or down, or if there's any causal relationship? And he's absolutely right. We're never going to know, I don't think. So it's going to be an interesting couple of years. I'd be interested,
Well, it's interesting to me how much it's also an exercise in symbolic politics.
Yes.
That is, as Joseph emphasizes, it is not at all clear that a great deal of any significance is at stake in terms of actual use or access or regulation. This was, in a sense, something one might say that wasn't broken. There's almost no political possibility of getting any federal gun legislation through the National Congress. 44 states recognize in their state constitution limits on state and local regulation of guns. They did exactly sort of they recognized the right and then always upheld the legislation, which emphasized the fact that as long as you say there's an individual right to handguns, that makes people happy enough, and then they don't mind that the courts uphold, regulations under it. So in that sense, the system was working. This was not there was not a lot of effective gun regulation out there. There are a few cities where the handgun ban was actually quite useful in Washington, because when you arrested someone and they had a gun, you could always make that charge stick. There's not a lot of mens rea or proof or difficult problems that go with that. And the problem in a densely populated urban area is that handguns are easily concealable. They can be taken on subways, on buses, in government buildings, into schools, into shopping malls, into all the densely packed areas where long guns do not pose nearly the same threat, so that there's a reason for singling out one particular type of weapon. One of the questions in Heller was, unless you're someone who for some reason can't physically operate a long gun, why is a handgun particularly necessary for self-defense? But I think underlying this is that there is a notion that there was a Second Amendment rights movement. And I think on the other side, sort of a gun control symbolic politics that had its own symbolism issues, so that the court was plunged in to vote, between the pickup truck people and the Brie and Chablis people, in this sort of holy war over social values that made it much more intense than the actual amount of regulation. That for a case that is this, historic, I'm not saying it has no consequence, but for a case that has this much enormous importance, it's not going to have the consequences that are nearly what Roe versus Wade had as consequences. Whether you think those consequences are good or bad, there's no question, but it's been enormously consequential. And whether you think it's good or bad, there's going to be, I think, no question that Citizens United is going to be enormously consequential. I don't see that here, and yet it generated the same or more intensity around it in a way that lets me see that the court and did something that it might ought to be hesitant to do, which is to jump in where it's involved in this kind of social media. It also makes me think that Roe versus Wade is going to be overruled. And the reason is because I think there is a jurisprudential movement that sees Roe versus Wade as fundamentally inconsistent with that view of jurisprudence, and that law won't be cleansed until the words Roe versus Wade is hereby overruled are uttered, even though that might not have much in the real world consequences as compared with simply allowing regulation where it really has an effect, which is regulation that prices and regulates abortion out of the reach of women who are low income, youthful poverty, living in rural areas, et cetera, which the court is already going to uphold. So it's not, so I think it may well be, just in the way that declaring an individual Second Amendment right was sort of had huge force behind it, wholly apart from its operational qualities. I think there is some sense, I feel, in which uttering the words Roe versus Wade is hereby overruled has the same kind of hydraulic, symbolic, social consequence force behind it.
So one way of piecing together Tom's observations with at least part of Walter's is, what is driving the outcome in Heller, in McDonald? Right. What kinds of evidence or considerations or approaches to interpretation are decisive? Right. Why does the court split 5-4 in the way that most commentators identify as ideological? Right. You've got 9 amateur historians. Is it just a good faith disagreement about what the history provides, and each side just happens to think that it's so clear in their favor? Is it just a good faith dispute among amateur social scientists about what the empirical evidence is? Right, and what kind of evidence you would need to come out the other way, right? Or do you have these kinds of competing normative visions, these different understandings of the American ethos, who we are as a people, laden with symbolism, laden with assertions of both individual and collective identity, coming after a decades-long conservative political movement that took the now lawful understanding of the Second Amendment. What is law today? I mean, as recently as 2 decades ago, was dismissed by the conservative Chief Justice of the United States, Warren Burger, as fraud. He said the biggest piece of special interest fraud ever perpetrated on the American people, right? Now that's law, right? And so I think there are lessons here about where constitutional law comes from and how it changed, and at least on certain kinds of questions, on Heller-type questions, what actually drives the outcomes in these cases. Any last words? We've got a couple of minutes.
No, just one last thought, that it just shows, when you look at these cases again, it just shows you the enormous consequences that Justice O'Connor resigned when she did and was replaced by Justice Alito. I cannot remember since 1938 as consequential a change of personnel on the court.
Do you think it would have been different with Justice O'Connor?
Yeah, that's interesting.
I do, actually.
Now,
I
could you
I'm surprised.
and in the 1 minute we have left, could you say why? Because I think Justice O'Connor would describe herself as sort of the rugged individualist, grew up on a ranch, right? Rode horses, I imagine shot
She
some
understands
firearms.
the American public and, you know.
I understand that, but I think she would have been reachable that the Second Amendment doesn't do this. And she knows in a way that the faux cowboys on the court don't. She's a real cowgirl. She understands that in all the states that Breyer mentions, where over 60% of the people have handguns in the home,
Right.
all those Western states, there's not going to be any regulation of guns out there. There's not going to be, people are not going to be adopting, you wouldn't be able to get a vote. You only vote in politics to vote for gun restrictions in Wyoming or Utah.
Let me put the question this way. Why does then presidential candidate Obama endorse the outcome in Heller? Right? Why does public opinion exceed 70% in favor of the decision? So the court gets Obama running for president, right, but they wouldn't have gotten O'Connor.
I just think she's reachable on this. I just think that she has some sense of restraint and is not as caught up in the symbolic politics of these issues
Okay.
As others may be. I would love to have a chance to re-argue Heller with Justice O'Connor as the deciding vote.
Right. All right, well, thank you all very much, and thanks to you folks for being here.
Produced by Duke University. Online at duke.edu.